So the adjuster assigned to your claim has already made a phone call, not to you or your doctor, not to your attorney, but to a licensed private investigator. Their job is simple. Follow you for 3 days. Film everything that contradicts your medical records. You carry a grocery bag. You're playing catch with your kid. Bending to grab a package off of your porch. That footage does not prove that you are fine. It does not have to. It just has to make a jury hesitate. I'm Jason Marker, 25 years as a personal injury attorney here in Illinois, and the people who lose the most to surveillance are the ones who had no idea it started the day they filed. That investigator may already be parked outside of your house, and every hour that you don't know what they're documenting is an hour that they're building a case against you. One phone call from an adjuster can put a licensed investigator on your file for days. Let me tell you about Marcus. He had a herniated disc from a rear end collision. Doctors told him to limit physical activity. His case was very strong. 4 months in, the insurance company dropped footage. 3 days of video, Marcus carrying groceries, tossing a football with his son, helping a neighbor move a couch. Nothing extreme, but the adjuster took those clips and argued that Marcus was exaggerating his injuries. The case did not collapse, but it got much harder. Weeks of extra work that never should have been necessary. Here's how the process works. Once a claim crosses a certain dollar threshold, the adjuster may authorize a private investigator. Illinois requires investigators to be licensed under 447, but that license does not limit what they observe in public spaces. Parking lots, parks, sidewalks, your driveway. Anywhere you're visible from a public vantage point is fair game. They can't enter your home, they can't aim a camera through your window, but everything you do outside those walls is documented in fair game. Here's the trap. The adjuster is not looking for proof that you're fine. They are just looking for footage that looks inconsistent with your medical records. A 30-second clip of you lifting a bag does not mean that your back is healed, but stripped of context, shown to a jury, it raises doubt, and doubt is all they need to drive your settlement down. What you need to do is confirm whether your adjuster has crossed a threshold where surveillance becomes likely. Ask an attorney. The adjuster is betting that you'll slip during one of the 3 predictable windows. Window 1, right after you file. The insurance company is still sizing up your claim. They want baseline footage of your activity before your attorney has the chance to have counseled you. Window number 2, the days before your deposition or an independent medical exam. These are moments where your stated limitations will be tested under oath by a doctor that the insurance company selected. The adjuster wants footage that contradicts whatever you're about to say. Window 3, milestones in your treatment. Physical therapy benchmarks because you are feeling better. Times when you might physically push yourself because you're feeling better. And the investigator is there to capture it. And here's what people miss. The investigator does not announce themselves. They sit in a parked vehicle. They follow you when you leave. They document where you go, what you carry, how you move, and who you're with. You will not know that they're even there unless you're paying attention. If you notice some unfamiliar vehicle outside of your home on consecutive days, or you feel like you're being followed, document it. Note the vehicle, the time, the location. Tell your attorney. This is not paranoia. This is how significant claims work. Here's what to do. Preserve any notes or observations about suspicious vehicles or people near your home. Your phone is your best witness. The adjuster already has your social media archived, probably within hours of your claim being filed. Facebook, Instagram, TikTok, X, LinkedIn, even Nextdoor. Insurance adjusters will locate every public profile that you have and screenshot everything. Photos that you've posted, photos that friends have tagged you in, location check-ins, event RSVPs, comments. Let me share with you what this looks like. Say that your name is Sophie, you've got a neck injury, still healing. Your sister throws a birthday party and posts a photo of you at the table standing, laughing, holding a plate. You look healthy, you look happy. You look like someone who's not in serious pain. It does not matter that you were exhausted afterwards. It does not matter that you could barely move the next morning. The photo does not show that. The one image becomes 30 seconds of evidence against 6 months of medical treatment and documentation. Listen, they already know these things. You do too. The adjuster's team also conducts open source investigation, Yelp reviews from a restaurant visit, a comment on the community Facebook page, a gym check-in, a friend's post tagging you at an outing. None of these things proves anything by itself, but assembled together, they build a picture that suggests that you were more active than you actually claimed. and that picture ends up in front of a jury. What you should demand from every family member and close friend is to stop tagging you publicly until your claim is resolved. Do nothing else, do this. 4 words, memorize them. Restrict, lock, silence, tell. Restrict means follow your medical restrictions, honestly. Your doctor sets those boundaries for a reason. They say short walks are fine, take short walks. Do not stop living your life, but do not exceed what your physician documented. If your records say you cannot lift more than 10 pounds, your behavior in every setting, at every home, at the store, at a family gathering, everything needs to match that. The risk is not activity. The risk is activity that contradicts your records. Lock means lock down every social media profile the day of your accident. Set everything to private. Turn your location sharing off. Turn off geotagging on your camera settings. Do not post photos, videos, or updates while your claim is active. Silence means do not discuss the claim or your injuries anywhere online. Not in posts, not in comments, not in private messages that may be subject to discovery. Do not write about the accident on any platform. Do not complain about the insurance company. Do not post about your recovery progress. Tell means tell your attorney everything before the insurance company uses it against you. This is the most important word of the 4. If you danced at your cousin's wedding, tell your lawyer. If you helped unload a moving truck, even though your restrictions said not to, tell your lawyer. If you walked around Wrigleyville for a few hours at a Cubs game, tell your lawyer. The attorney who knows everything can manage it. The attorney that gets blindsided by surveillance footage in a litigation cannot. Restrict, lock, silence, tell. What to preserve? This list. Screenshot it. Text it to anyone in your household who might post about you online. The single biggest mistake people make with surveillance is not knowing it already started. If you want to see how adjusters use another weapon, recorded statements, to get you to say things that damage your own claim, watch this next video. If you have an active case and you're not sure what the insurance company already has on you, then that's a conversation you need to have now, not later. Call Marker Law. Our number is in the description. I'm Jason Marker. Do not let 30 seconds of footage undo months of legitimate treatment. Thank you for watching. We'll see you on the next video.